6 justices voted in favor, 3 opposed, and with that narrow margin, the complete legal structure that UJS had relied upon to evaluate firearm regulations across this nation shattered entirely. That occurred 2 years prior, yet what followed shortly after is what nearly everyone seems to be ignoring, and it may decide if the firearm resting in your closet today remains permissible or transforms into something authorities classify as illegal contraband. The cascade of events is unfolding more rapidly than many observers comprehend, and unless you're monitoring the legal petitions accumulating throughout various federal districts, you'll arise one day completely unaware of what transformed during your inattention. Allow me to guide you through precisely what transpired, what it signifies, and why the coming year may represent the most pivotal time frame for weapons rights in decades. The matter was New York State Rifle and Pistol Association versus Bruen, decided by the Supreme Court on June 23, 2022. Superficially, it concerned carrying firearms. It originated from New York. It involved licensing and focused on whether authorities could compel individuals to demonstrate exceptional circumstances before bearing pistols openly. However, the principle established in that ruling extended far past carrying permissions. It fundamentally reconstructed the basis beneath every weapons case nationwide. Here's what was happening. Prior to Bruen, regional courts had established a comfortable little routine. A weapons statute faced challenge. The bench would acknowledge the Second Amendment. They concede that indeed it safeguards personal liberties, then shift toward weighing competing interests. They would balance state concerns regarding community protection against impositions upon firearm possessors, and virtually without exception, the state's position prevailed. It operated as a dual-phase methodology, and it granted magistrates extensive discretion to sustain limitations merely by determining the jurisdiction possessed sufficient justification. Bruen dismantled this method entirely. The 6-member majority declared the proper approach for assessing weapons constraints involves examining the Second Amendment's explicit language, then determining whether authorities can identify comparable historical precedents from the Revolutionary period or the era around the 14th Amendment's adoption. And no additional balancing of interests, no yielding to parliamentary determinations regarding appropriateness. Should the activity align with the Second Amendment's text, the onus completely transfers to authorities to furnish authentic historical parallels. That may appear to be merely an esoteric judicial distinction, yet practically, it constituted a monumental transformation. Instantly, every weapons limitation that had endured courtroom scrutiny under the previous balancing approach became exposed. Every determination founded upon the dual-phase structure rested upon foundations that had vanished, and every subsequent matter would be contested upon ground significantly more advantageous to opponents. Firearm proprietors recognized immediately this represented an enormous triumph. Yet here exists the essential subtlety that cannot be overlooked. Bruen never specifically tackled long guns. It never referenced AR-15s. It never invalidated any assault weapons prohibition. What it accomplished was provide weapons rights supporters the most formidable legal instrument they've ever possessed. And the inquiry became, how rapidly and extensively could they leverage it in subsequent litigation? That inquiry received an emphatic and unmistakable response on December 22, 2025, when the Justice Department initiated litigation against Washington, D.C. regarding its prohibition against registering AR-15s and comparable semi-automatic weapons. This wasn't a minor technical objection or limited grievance concerning some obscure regulatory detail. The DOJ targeted the prohibition's core directly and requested the bench issue lasting injunctive relief, a compulsory judicial directive preventing D.C. from persistently obstructing lawful residents from registering constitutionally safeguarded weapons. The petition constructed its position upon dual foundations. The first was widespread ownership. The DOJ contended that AR-15 pattern long guns and equivalent semi-automatic weapons rank among America's most extensively possessed firearms, maintained by countless regular civilians for completely legitimate objectives, encompassing residential protection, practice, and leisure marksmanship. Under the structure established through both Heller and Bruen, weapons held broadly for legitimate objectives sit comfortably within Second Amendment safeguards. The second foundation challenged the architecture of D.C.'s regulatory apparatus itself. The jurisdiction established mechanisms where particular weapons simply couldn't be registered, yet D.C. simultaneously criminalized possessing unregistered weapons, creating residents caught within an irresolvable paradox. You cannot register the long gun, and you cannot legally own a long gun that is not registered. The DOJ portrayed this as a constitutional snare, a framework engineered to achieve prohibition's results while technically circumventing prohibition's terminology. This carries immense significance because it wasn't some external activist organization pursuing this challenge. It was the federal government itself. When the DOJ adopts a stance in federal litigation, magistrates pay attention, state prosecutors pay attention, legislators drafting fresh limitations pay attention. The federal government's influence pressing against a weapons prohibition alters the complete litigation dynamic and transmits a warning to every other jurisdiction maintaining comparable prohibitions that legal exposure has substantially increased. Earlier during 2025, the Attorney General had already indicated the department would prioritize Second Amendment enforcement more aggressively. A specialized Second Amendment division formed within the DOJ. Then emerged the DC litigation. This wasn't coincidence or spontaneity. It was a calculated policy decision shifting federal posture from defending weapons regulations toward actively contesting them under specific circumstances. On June 2nd, 2025, the Supreme Court refused to consider Snope against Bruen, challenging Maryland's assault weapons prohibition. Superficially, this appeared as defeat for weapons rights proponents. The Fourth Circuit had sustained the prohibition, and the Supreme Court permitted that determination to stand. Yet what occurred beneath that refusal narrated an entirely different account. Justice Kavanaugh authored commentary explaining his perspective. He recognized that challengers had presented compelling reasoning. He highlighted that AR-15 pattern long guns are possessed by countless Americans and remain lawful throughout most jurisdictions. Then, he articulated something that electrified the legal profession. He stated the court ought to, and probably shall, address whether these prohibitions are constitutional shortly. Justice Thomas was more explicit. He indicated he would have accepted the matter and wouldn't delay further determining whether governments may ban the nation's most prevalent long gun platform. Justices Alito and Gorsuch similarly signaled willingness to hear the case. 4 justices publicly declared this matter requires resolution, and at minimum, 2 explicitly indicated they view these prohibitions as constitutionally questionable. You need 5 votes to win a case at the Supreme Court, but you only need 4 to grant review. That means the next time a clean vehicle for this question arrives at the court's doorstep, the chances of it being accepted are extraordinarily high. This is the part that so many people are misunderstanding. The court did not reject the argument. It declined to hear one particular case at one particular time. The justices who wrote about it went out of their way to explain that the underlying question is not going away, and several of them essentially previewed how they would vote. Here's where the rubber meets the road, and where a lot of people are getting it wrong in both directions. If you live in a state that does not have an assault weapons ban, the combination of Bruen and the DOJ's enforcement posture strengthens the legal foundation under your ownership rights. The argument that commonly owned semi-automatic rifles are constitutionally protected arms is gaining momentum in the courts, and that momentum makes it harder for any future federal ban to survive legal challenge. If you live in a state that does have a ban, whether that is Maryland, California, Illinois, New Jersey, or anywhere else, these developments do not erase your local law overnight. Your state's restriction is still enforceable until a court with jurisdiction over your state issues an order saying otherwise. That is an absolutely critical distinction. The legal arguments are stronger than they have ever been. The trajectory is more favorable than it has ever been. But trajectory is not the same thing as a final ruling, and acting as if a ban has been struck down before it actually has been struck down is a fast way to end up in serious legal trouble. The phrase you need to understand is common use. It has been doing heavy lifting in Second Amendment jurisprudence ever since Heller, and it is about to do even more. The concept is straightforward. If a type of firearm is commonly owned by law-abiding citizens for lawful purposes, it is presumptively protected by the Second Amendment. The government cannot simply declare something unusual or dangerous when millions of people own it and use it responsibly every single day. This logic is what makes the AR-15 question so potent. There are estimated to be well over 20 million AR-15 pattern rifles in civilian hands in the United States. They are the single most popular rifle platform in the country. Calling them unusual in the face of those numbers is an argument that gets harder to make with every passing year and every additional unit sold. You have to understand the difference between a promising legal argument and an enforceable court order. You have to know your local laws, even while those laws are being challenged. And you have to stay informed, because the next major filing or ruling could land with very little warning. That's it for today. See you in the next video.